Right now, a federal system is quietly scanning the bank accounts of millions of Americans who receive supplemental security income, not next year, not after a new law passes. It has been running since August 1st, 2025, and its reach has been expanding every month since. As of April 2026, that system has been revised again. It now covers every single new SSI claim, every allowance, every appeal reversal, every reopening that grants initial eligibility. You are not getting a warning letter before it runs. You are not being asked for your permission at that point. You gave permission when you signed your application. And if that system finds something the government considers a discrepancy, an old account you forgot about, a joint account you share with a family member, a balance that briefly crossed the wrong line, the consequences can land on you months before you ever understand what happened. That is not a description of what might happen. That is the mechanics of how the system works today. Here is what we are going to cover. First, exactly how the SSA's access to financial institutions system has changed and what it is now capable of finding. Second, the resource limits that have not moved in over 30 years and why they trap honest people. Third, how a clean record can still generate an overpayment demand and what that demand can now cost you. Fourth, the account checklist you need to run right now. And fifth, how to recognize the scams that will use this news to steal from you because they are already operating. The most important action item comes at the end. Stay with me. The system at the center of all of this is called the Access to Financial Institutions Program, or AFI. SSA has used some version of this program for years. What most people do not understand is that the version running today looks almost nothing like the earlier one. The old model was limited. It checked accounts you told SSA you had, and it only ran at application and at periodic redeterminations, reviews that for some recipients happen once every 1 to 6 years. The gap in between was enormous. An OIG Inspector General analysis found that in fiscal year 2023, 89% of overpayments caused by excess resources in financial accounts occurred during that gap, after initial approval, before the next scheduled review. The agency was essentially running the check, then going blind for years at a time. That is what changed on August 1st, 2025, when SSA issued Emergency Message EM2546. The directive expanded AFI verification to cover all SSI claim allowances, including initial claim reopenings and appeal reversals that establish eligibility for the first time. The OIG had estimated that more frequent AFI searches could have prevented approximately $2 billion in overpayments in fiscal year 2023 alone. That number made inaction politically untenable. Here is the mechanism you need to understand. AI does two things. The first is balance verification. The system electronically contacts financial institutions to confirm whether the balances you reported match what the bank actually has on file. The second function is what the SSA calls geographic searches. Instead of only checking the accounts you disclose, the system queries financial institutions located near your home address, up to 10 separate geographic searches per person per review. If you lived in Ohio 3 years ago and banked at a credit union there before moving to Texas, AFI can still find that account. A GAO audit documented that AFI reaches approximately 96% of the financial institutions where SSI recipients hold direct deposit accounts. The categories it covers are broader than most people realize. Checking accounts, savings accounts, money market accounts, certificates of deposit, Christmas club accounts, credit union accounts. If it is held at a federally insured institution and can be converted to cash, the system is built to reach it. There is also a revised directive, EM2546 Rev, updated in April 2026. That revision expanded mandatory account verification to every SSI claim allowance going forward, not a pilot program, not a regional rollout, everyone. What this means practically is that the era of the SSI review being an occasional self-reported process is over. The agency has built infrastructure for something closer to continuous verification, and it is deploying it. To understand why the AFI expansion matters so much for ordinary seniors, you have to understand the resource limits it is enforcing. The SSI resource limit is $2,000 for an individual and $3,000 for a couple. Those numbers sound straightforward. Here is what makes them dangerous. They have not changed since 1989. $2,000 in 1989 had roughly the same purchasing power as $5,200 in 2025. The limit has been frozen while prices more than doubled. Meanwhile, the people subject to it are living longer, facing higher medical costs, and trying to maintain a modest buffer against emergencies on a fixed income. Think about what this means in concrete terms. An SSI recipient gets a one-time gift from a family member, say a birthday check for $300 on top of a modest savings balance. If that brief deposit pushes their account over the $2,000 line on the date SSA happens to verify their balance, they may have technically exceeded the resource limit. They may not have even spent the money yet. The system does not ask whether it was temporary. It checks the balances of a specific point in time. Joint accounts are another common trap. If you share a checking account with an adult child, a common arrangement for convenience or for managing bills, the SSA's default position is that every dollar in that account belongs to you, the SSI recipient, unless you can demonstrate otherwise. An adult child with direct deposit sending $3,000 a month through a shared account can make an SSI-eligible parent look like they have resources they do not actually control. A September 2024 Inspector General report found that SSA made inaccurate SSI resource determinations for recipients, paying them $718 million in payments they were not eligible for, largely because of undisclosed or misunderstood financial accounts. That report estimated that 800,000 applicants and recipients had underreported their financial account balances by $100 or more, and 219,000 had failed to report all accounts they owned. That is not a portrait of mass fraud. Most people are confused about the rules, or they genuinely forgot an old account, or they did not understand that the joint account counts against them. But the system does not ask about intent, it checks the math. Here is the scenario that advocacy groups call the most financially devastating sequence in federal benefits. You receive SSI benefits for a year or two. During that time, something in your financial picture briefly changed. A gift, a deposit, a joint account fluctuation that pushed your resources over the limit for a period. SSA's expanded AFI checks catch it, possibly months or years later. You receive a notice saying you were overpaid. Now you owe the money back. This is not hypothetical. It is the everyday reality of how overpayment cases develop. For SI-specific Title 16s, the recovery rules have remained at a 10% withholding cap. 10% of the 2026 maximum monthly SSI benefit of $994 for an individual is approximately $99 a month. If you were overpaid by several $1,000s, that means years of monthly deductions. That matters less as a financial shock than as a bureaucratic reality you will be living with. For Title II benefits, retirement survivor payments, and Social Security disability insurance, the situation became significantly more volatile in 2025. In March 2025, SSA announced it was returning to a 100% withholding default for new overpayment notices. That meant your entire monthly check gone until the debt was repaid. Less than 2 months later, on April 25, 2025, the agency reversed course again, setting the default at 50% withholding for Title II benefits. The SSA issued no public press release. The change appeared in an internal emergency message. Richard Fiesta of the Alliance for Retired Americans described the whiplash to CNBC as going from 10% to 100% to 50% in the span of 100 days. For someone living on their benefit as their sole income source, even 50% withholding can mean choosing between medication and food. The former SSA commissioner who instituted the 10% cap, Martin O'Malley, put it plainly in an April 2025 interview with KFF Health News. He said that for anyone depending entirely on their Social Security check, having half of it interrupted could mean going without medicine instead of buying medicine and food. He called the earlier 100% policy clawback cruelty. Here's what you can do if you receive an overpayment notice. First, you have 60 days from the date of the notice to file a request for reconsideration. If you file that appeal within 10 days, your benefits continue unchanged while the review proceeds. Second, you can request a waiver using Form SSA 632, which asks the agency to forgive all or part of the overpayment on grounds that repayment would cause hardship or that the overpayment was not your fault. Third, even without a formal waiver, you can contact SSA and request a reduced repayment rate. The agency can agree to any monthly amount, including a few dollars per month, if your financial situation supports it. SSA's main phone number is 1-800-772-1213. Do not ignore an overpayment notice. The window for appeal closes fast, and missing it forfeits your rights at that level unless you can show good cause for the delay. You have been listening carefully, and that means you are exactly the kind of person who catches these problems before they become crises rather than after. This section is the payoff of everything we have covered. Run through this list methodically. Every account, every institution, every category. Step 1. List every account where your name appears, not just accounts you actively use. Bank accounts you opened years ago and stopped using. Accounts where you are a named co-owner or authorized user. Accounts tied to a former address. Accounts at credit unions in states where you used to live. The geographic search function can find accounts in multiple states. An account with $12 sitting dormant in a bank in a city you moved away from is still a countable resource if you technically have access to it. Step 2. Total the balances across all those accounts on the same day. The SSI resource limit is $2,000 for individuals and $3,000 for couples. That total needs to stay below the limit on every day SSA could run a verification check, which now includes the date your claim is approved, the date of any red determination, and the date of any life event that triggers a review. Getting married, moving, changing household composition, starting or stopping any employment, all of these can trigger an unscheduled AFI check. Step 3. Examine every joint account. If you share an account with a family member, understand that SSA presumes the entire balance belongs to you unless you can document otherwise. The documentation standard requires you to show the funds came from the other person. If the account is used primarily for someone else's finances, but your name is on it for convenience, consider whether your name needs to be on it at all. Step 4. Report any account you have never reported. If you submit this information voluntarily before SSA finds it through AFI, your position is significantly better than if the agency discovers it through automated search and concludes you concealed it. The SSA's general phone line is 1-800-772-1213. You can also update records online through the My Social Security portal at account. Step 5. Document the source of any large or unusual deposit. If a relative sent money, have documentation ready, a note, a bank transfer record, anything that establishes where the funds came from. If it was a one-time gift rather than recurring income, that distinction matters. An 89-year-old parent's tax refund deposited into a shared account looks very different to an SSA reviewer with and without documentation. Step 6. Know what is exempt. Your primary residence is not a countable resource. One vehicle, regardless of value, is not countable. Burial funds of up to $1,500 per person set aside specifically for that purpose are generally excluded. Funds in an ABLE account under POMS rules are also treated differently. The list of exemptions is specific and detailed. If you have questions about whether a particular asset counts, the SSA Policy Operations Manual, known as the POMS, is available at ssa.gov, and a legal aid organization or Social Security attorney can help you interpret it. There is a parallel development that you need to understand because it shapes the broader environment your benefits information now exists in. In June 2025, the United States Supreme Court ruled 6-3 in Social Security Administration versus ASME that the Department of Government Efficiency, DOGE, could access Social Security Administration records while litigation over the legality of that access continues. The data DOGE can access is not abstract. It includes Social Security numbers, medical and mental health records, lifetime earnings records, banking information, immigration and work authorization status, and information from data sharing agreements SSA maintains with the IRS and the Department of Health and Human Services. Former SSA Senior Advisor Kathleen Romig described it to CNN as data that runs from cradle to grave, adding that DOGE operatives would have what she called God-level access to Social Security numbers, earnings records, bank routing numbers, and mental and reproductive health records. The 3 dissenting justices, including Justice Ketanji Brown Jackson, warned that the ruling creates grave privacy risks for millions of Americans, noting that DOGE received far broader data access than SSA customarily allows even for fraud, waste, and abuse investigations. The legal challenge continues in lower courts, and the Supreme Court's stay is temporary. But as of today, that access is active. What this means for you practically is not a reason to panic. Your benefits do not change because of DOGE access, but it is another reason to ensure your SSA records are accurate and current. If your file contains outdated information, an old address, an account that no longer exists, income data that has not been updated, that creates discrepancies that can be flagged in any kind of automated cross-referencing, an accurate file is the best defense regardless of who is doing the reviewing. Every major Social Security policy change creates a new wave of criminal activity directed at seniors. This one is no different. The SSA Office of the Inspector General issued a warning about a significant increase in government imposter scam emails in February 2026. A separate OIG alert in July 2025 warned about telephone scammers using real SA and OIG employee names pulled directly from public agency directories to make their calls sound legitimate. The FTC documented that government imposter scams skyrocketed by 40% in 2025. In 2023, consumers reported losing more than $126 million to Social Security scams alone. That number has been rising. Here is the specific fraud pattern tied to this bank verification news. A scammer calls claiming to be an SSA compliance officer. They tell you that the new bank verification system has flagged your account, that your Social Security number has been suspended, that you owe a fee, that your benefits will be cut off unless you act immediately. They may use your actual name. They may know your zip code. They may even cite a case number. None of this makes them real. The SSA has published a clear list of things it will never do. It will never call to demand payment. It will never threaten you with arrest for not paying. It will never ask you to buy gift cards, wire money, move funds to a protected account, use cryptocurrency, or hand cash to a courier. It will never tell you your social security number has been suspended due to criminal activity. It will never claim to need your bank account number to verify compliance with the new rules. If the real SSA needs to contact you about your accounts, that contact comes by mail, addressed to you through the United States Postal Service, or through a message in your My Social Security account at ssa.gov myaccount. Those are the two channels. Everything else is a scam. Here is a specific scenario pulled from OIG documented cases. Your phone rings. The caller identifies himself as a senior compliance specialist at the Social Security Administration. He tells you there is an irregularity in your account connected to the new bank verification system. He says the system flagged a discrepancy, and your benefits may be suspended within 72 hours unless you verify your direct deposit account number. He offers to transfer you to a supervisor who sounds authoritative and calm. Somewhere in that conversation, he asks for your bank account number or asks you to confirm it. Hang up. Do not confirm anything. Call SSA directly at 1-800-772-1213 to verify whether any actual issue exists. Report suspected scams to oig.ssa.gov. The OIG has been explicit that knowing the red flags is one of the most effective protections available. People who understand how the real SSA operates are far less likely to fall victim than people who don't. Share this information with anyone in your life who receives Social Security. Here is where we land after everything you have heard today. The expansion of the AFI system, the April 2026 revision to EM 2546, the Dodge data access fight, the overpayment withholding changes, these are not isolated events. They are part of a coherent direction. The SSA is moving toward more frequent, more automated, less self-reported verification of financial eligibility. That is happening regardless of which party controls Washington, because the Inspector General data showing billions in preventable overpayments made inaction indefensible. What that means for every SSI recipient, and for anyone who helps an SSI recipient manage their affairs, is that the margin for administrative error has shrunk considerably. Accounts you forgot exist, balances that briefly crossed a line, joint accounts that were never fully understood. These are no longer things the system is likely to miss. The system is now specifically designed to find them. The checklist in this video is real protection. List every account, total the balances, examine every joint account, report anything unreported, document every unusual deposit, know your exemptions. These steps do not guarantee you will never receive an overpayment notice, but they give you the strongest possible position if you do, and they give you documentation that supports a waiver request or an appeal. One question I want to leave you with: the SSI resource limits, $2,000 for an individual, frozen since 1989, have not kept pace with inflation, medical costs, or the basic reality of what it takes to manage a modest buffer in retirement. The AFI system is expanding its enforcement of a rule that has not been updated in over 3 decades. Is that the right approach? Is enforcement without modernization actually serving the people these programs were designed to protect? I want to hear your answer in the comments. If someone in your life needs to hear this, a parent, a neighbor, a friend on a fixed income, share this video with them. The scammers already know about these changes. The people who need protection deserve to know too.